Welcome back, everybody, to the On the Docket podcast. For the 5th episode, we will once again be looking at a case that involves criminal procedures and rights of the accused. This case is special for a multitude of reasons. It's special because it's the oldest case we've discussed on the podcast, going all the way back to the turn of the 20th century, and it's also special because it has become the subject of various internet memes and misinformation campaigns over the past few years. Today, we will be discussing Bad Elk v. United States. John Bad Elk was a tribal police officer for the Oglala Lakota Sioux tribe. Bad Elk lived on the Pine Ridge Reservation in South Dakota. In 1899, Bad Elk reportedly fired several shots from or near his home on the reservation, although there were no witnesses to the incident. Captain Gleason, who was the police captain for the Oglala Lakota Sioux tribe, heard the shots and confronted Bad Elk about it. According to Gleason, Bad Elk said that he was the one who fired the shots and that he had done it for fun. Gleason then told Bad Elk to stop by his office at a later date to discuss the incident, but Bad Elk never showed up. Gleason then ordered 3 other officers to go to Bad Elk's home to arrest him and take him to the Pine Ridge Agency. Now, it's important to note what the laws were regarding shooting a firearm back in 1900. The tribal law did not list the firing of a weapon as a crime. However, South Dakota law classified the discharge of a weapon without reason as a misdemeanor. In order to arrest somebody on a misdemeanor charge, the arresting officers would need a warrant, or the crime would need to happen within the presence of an officer, so keep that in mind. The 3 officers Gleason sent showed up to Bad Elk's residence, and Bad Elk refused to come with them. He said that he would go with them in the morning instead. The 3 officers then walked back to Gleason's office and told him that John Bad Elk was refusing to come with them. At that point, Gleason told them to go back and arrest Bad Elk this time. The officers then walked back to Bad Elk's residence to arrest him. Again, Bad Elk refused to go with them, and this is where things got hairy. According to John Bad Elk, another officer named John Kill's back reached for his pistol. In turn, Bad Elk reached for his gun and shot John Bad Elk, killing him. The 2 other officers managed to arrest Bad Elk, and he was charged with the murder of John Kill's back. John Bad Elk's trial was held in the 8th Circuit Court for the District of South Dakota. At trial, Bad Elk's representation said that Bad Elk's actions were out of self-defense. They argued that because none of the officers had a warrant for Bad Elk's arrest, and because none of them had been present when Bad Elk allegedly fired the several shots, they had no right to arrest Bad Elk. They claimed that an unlawful arrest amounted to kidnapping and that John Bad Elk had the right to use any means necessary to escape the situation. However, there is another aspect of Bad Elk's trial that is important to note here. Bad Elk requested that the jury be informed that he had the right to resist an unlawful arrest. This request was denied, and instead the jury was informed that he did not have the right to resist an unlawful arrest unless the police had used excessive force. The jury returned a guilty verdict and sentenced John Bad Elk to death by hanging. After being sentenced to death, Bad Elk appealed his case to the U.S. Supreme Court, arguing that the Circuit Court had made an error when instructing the juror that he did not have the right to resist an unlawful arrest. The U.S. Supreme Court granted Bad Elk's petition for certiorari and heard the oral arguments sometime later. Now, because this case is so old, I wasn't able to find Bad Elk's petition for certiorari or the transcript for oral arguments, so instead I'm just going to introduce the justices and then jump straight into the opinion. With any Supreme Court case, it's important to know which justices will be hearing the case. For Bad Elk, his case was heard by the Fuller Court, meaning the Chief Justice at the time was Melville Fuller. Fuller was nominated to the court in 1888 by President Grover Cleveland in order to replace the deceased former Chief Justice Morrison Waite. His nomination received mixed reviews in the Senate. Senate Republicans were upset that he had avoided serving in the military during the Civil War, and they portrayed him as a copperhead, which was the term given to anti-war Democrats at the time. However, despite this controversy, he was confirmed to the Senate on a 41-20 vote in 1888. Interestingly enough, the court under Fuller didn't hear too many cases regarding the rights of the accused, so there isn't any good way to gauge Fuller's position on this topic. Alongside Fuller, we have Chief Justice John Marshall Harlan. Harlan was nominated to the court in 1877 by President Rutherford B. Hayes. Hayes became the president following the election of 1876, which is regarded to this day as one of the most hostile and controversial elections in American history. This is due to a number of reasons, but they aren't really pertinent to the story. I only mentioned the 1876 election because in 1877, Hayes sought to make amends by nominating a Southerner. Harlan was meant to replace the retired Associate Justice David Davis. In the Senate, Harlan's nomination was met with criticism from the stalwarts, which were a faction of Republicans that, among other things, opposed civil service reform. Regardless, though, Harlan was appointed to the High Court on a unanimous vote on November 29, 1877. On the court, Harlan differed from many of his colleagues in that he opposed judicial activism, supporting a strong national government, and often voted to uphold civil rights legislature. Next up is Associate Justice Horace Gray. In December 1881, President Chester A. Arthur nominated Gray to replace Nathan Clifford, who had passed away. In January of 1882, Gray was appointed to the court by the Senate. Again, because the court didn't accept too many criminal procedure cases during the Fuller Court era, we don't know much about Horace Gray's stance on criminal procedure. After Gray is Associate Justice David Brewer. Brewer was nominated to the court by President Benjamin Harrison in December 1889 to replace Stanley Matthews. He was confirmed by the Senate within the same month. On the court, Brewer acted as a moderate with a tinge of conservative influence. He was very supportive of the rights of minority groups in America, arguing for greater labor protections for women and supporting the rights of Asian immigrants. Moving on from Brewer, we have Associate Justice Henry Billings Brown. Brown was another Harrison appointment, being nominated in 1890 to replace the dead Samuel Miller. Brown was confirmed by the Senate on a unanimous vote on December 23, 1890. Because this case was so unique in its content, there isn't a whole lot that we can glean about Brown's jurisprudence, as there weren't many cases coming before the Supreme Court concerning what a person's rights were during an unlawful arrest. Following Associate Justice Brown, we have Associate Justice George Shiras, Jr. Shiras, Jr. was yet another nomination from President Harrison, and he was meant to replace Associate Justice Joseph Bradley. He was confirmed by the Senate in July of 1892 and remained there until 1903. As with some of the other justices mentioned so far, we can't really gauge or predict how he might rule on this case based on other cases he heard, because none of the other cases he heard during this time on the court were similar to this case. Next up is Associate Justice Edward Douglas White. White was nominated by President Grover Cleveland after his attempts to get William Hornblower and Wheeler Peckham on the court failed. During his time as an Associate Justice, the only notable case that White heard was the landmark case Plessy v. Ferguson, which I'll probably do an episode on at some point in the future. Moving on from Edward White is Associate Justice Rufus Wheeler Peckham. As I just mentioned, President Grover Cleveland attempted to get somebody named Wheeler Peckham on the Supreme Court, but that attempt failed. As it turns out, Wheeler Peckham was Rufus Peckham's brother, and the reason that his nomination failed was that a senator out of New York named David Hill managed to block his nomination. However, in 1895, David Hill's political influence had weakened enough so that Cleveland was able to nominate Rufus Peckham to the court as a replacement for the deceased Howell Edmonds Jackson, and Peckham was confirmed in January of 1896. On a topic adjacent to unlawful arrests, in 1908, Peckham authored the opinion for the case Ex parte Young, which determined that federal courts can issue injunctions against a state officer in order to prevent the enforcement of an invalid state law. Finally, we have Associate Justice Joseph McKenna. In 1898, President William McKinley nominated McKenna, who was a U.S. Attorney General at the time, to replace Associate Justice Stephen Field. He was confirmed the day after his nomination, but with a weak background in the field of law, he did not take his seat on the court for a few months as he worked to improve his legal acumen by attending law school. During his time on the court, McKenna struggled to develop a consistent jurisprudence. In addition to this, he suffered a stroke 10 years before his retirement from the position, and in those 10 years he struggled to author coherent opinions. So we've detailed the facts of the case, and we've introduced the justices. Let's refresh our memory on what the constitutional questions being asked here are before we get into the opinions. The first question being asked is whether or not a citizen has the right to use force to resist unlawful arrest, and if they do, are they also entitled to inform the jury of this fact? So with those questions in mind, let's hear the opinion. On April 30th, 1900, Associate Justice Rufus Wheeler Peckham delivered the unanimous opinion of the court, which is as follows. The plaintiff in error was convicted in April 1899 in the Circuit Court of the United States in South Dakota of the murder on March 13, 1899 of John Kilsback at the Pine Ridge Indian Reservation in South Dakota and sentenced to be hanged. The case is brought here on writ of error to the Circuit Court. Both the deceased and the plaintiff in error were Indians and policemen residing on the reservation at the time of the killing. Upon the trial, it appeared that the plaintiff in error on March 8, 1899, while out of doors, fired a couple of shots from his gun at or near the place where he resided. Soon after the firing, one Captain Gleason, who stated that he was what is called an, quote, additional farmer, unquote, on the same reservation, having heard the shots and meeting the plaintiff in error, asked him if he had done that shooting, and he said that he had, that, quote, he had shot it into the air for fun, unquote, to which Gleason responded by saying to him, quote, come around to the office in a little while and we'll talk over the matter, unquote. Thereupon they separated. As he did not come to the office, Gleason, after waiting several days, gave verbal orders to 3 of the Indian policemen to go and arrest plaintiff in error at his mother's house nearby and take him to the agency some 25 miles distant. No reason for making the arrest was given, nor any charge made against him. The policemen, one of whom was the deceased, went to the house where the plaintiff in error was stopping and came back and reported to Gleason that he was not there, and they were then ordered to return and wait for him and to arrest him. They returned to the house, but came back again and reported that the plaintiff in error said that he would go with them to the agency in the morning, that it was too late to go with them that night. Gleason then told them to watch him and see that he did not go away, and in the morning to take him to the Pine Ridge agency. The policeman then again went back to the house where plaintiff in error was staying and met him coming towards his mother's place. He went into the house, and one of their number followed him, found him smoking, and told him that they had come to take him to the agency at Pine Ridge. Plaintiff in error refused to go, and the policeman went outside. Another of them then went into the house, and in a few minutes both he and the plaintiff in error came out, and the latter saddled his horse, went over to the house of a friend, and they followed him. It was getting dark when he came back to his mother's house, still followed by them, and while following the plaintiff in error to his house on this last occasion, they were joined by others, so that when he went into the house, there were 4 or 5 men standing about it. In a short time, the plaintiff in error came out and asked of those outside, quote, what are you here bothering me for, unquote. The deceased said, quote, cousin, you are a policeman and you know what the rules and orders are, unquote. To which plaintiff in error replied, quote, yes, I know what the rules and orders are, but I told you I would go with you to Pine Ridge in the morning, unquote. Then, according to the evidence for the prosecution, the plaintiff in error, without further provocation, shot the deceased, who died within a few minutes. The policemen had their arms with them when they went up to where the plaintiff in error was at the time the shooting was done. This is substantially the case made by the prosecution. There is an entire absence of any evidence of a complaint having been made before any magistrate or officer charging an offense against the plaintiff in error, and there is no proof that he had been guilty of any criminal offense, or that he had even violated any rule or regulation for the government of the Indians on the reservation, or that any warrant had been issued for his arrest. On the contrary, Gleason swears that his orders to arrest plaintiff in error were not in writing, but given orally. Indeed, it does not appear that Gleason had any authority even to entertain a complaint or to issue a warrant in any event. The plaintiff in error testified in his own behalf and said that during the day he had been looking after the schools along the creek near the station, that was his duty as a policeman, that he arrived at his mother's house about 4:30 in the afternoon, and soon afterwards an Indian named High Eagle came into the house, stayed a minute or two but did not speak, then went outdoors, and Lone Bear came in and said that he was directed to take the plaintiff in error to Pine Ridge to Major Clapp. To which the plaintiff replied, quote, all right, but my horse is used up, and I shall have to go to my brother's, Harrison White Thunders, and get another horse, unquote. Lone Bear said all right. Then the plaintiff in error started for his brother's, and when he got there found that the horses were out on the range, and when they came in, his brother promised to bring one of them down to him. In this he was corroborated by his brother, who testified that he brought the horse over about dark. On his way back to his mother's, the plaintiff in error stopped at a friend's and got a Winchester rifle for the purpose, as he said, of shooting prairie chickens. When he went back to his mother's, he was there but a short time when the deceased and 2 or 3 others came to his house to arrest him, and the plaintiff in error went out, and according to his testimony, the following was what occurred. Quote, I asked John Killsback and High Eagle what they were bothering me all the while for. John Killsback said, you are a policeman and you know what the rules are. I said, yes, I know what the rules are, but I told you that I would go to Pine Ridge Agency in the morning. Then the deceased moved a little forward and put his hands around as if to reach for his gun. I saw the gun and shot, Then I shot twice more, and John Killsback and a high eagle ran off. John Killsback fell after he had gone a short distance. I shot because I knew that they, John Killsback and High Eagle, would shoot me. I saw their revolvers at the time I shot. This was in substance all the evidence. Counsel for plaintiff in error asked the court to charge as follows, quote, "From the evidence as it appears in this action, none of the policemen who sought to arrest the defendant in this action prior to the killing of the deceased John Killsback were justified in arresting the defendant, and he had a right to use such force as a reasonably prudent person might do in resisting such arrest by them." Unquote. The court denied the request and counsel accepted. The court charged the jury, among other things, as follows, quote, "The deceased John Killsback had been ordered to arrest the defendant, hence he had a right to go and make the attempt to arrest the defendant. The defendant had no right to resist him. It is claimed on the part of the defendant that he made no resistance and he was willing to go with the officer in the morning. I charge you, of course, that the officer John Killsback had a right to determine for himself when this man should go to the agency with him. In this connection, I desire to say to you, gentlemen of the jury, that the deceased, being an officer of the law, had a right to be armed, and for the purpose of arresting the defendant, he would have had the right to show his revolver. He would have had the right to use only so much force as was necessary to take his prisoner, and the fact that he was using no more force than was necessary to take his prisoner would not be sufficient justification for the defendant to shoot him and kill him. The defendant would only be justified in killing the deceased when you should find that the circumstances showed that the deceased had so far forgotten his duties as an officer and had gone beyond the force necessary to arrest defendant and was about to kill him or inflict great bodily injury upon him, which was not necessary for the purpose of making the arrest." Unquote. This charge was duly accepted too. We think the court clearly erred in charging that the policeman had the right to arrest the plaintiff in error and to use such force as was necessary to accomplish the arrest, and that the plaintiff in error had no right to resist it. The evidence as to the facts immediately preceding the killing was contradictory, the prosecution showing a killing when no active effort was at that very moment made to arrest, and the defendant showing an intended arrest and a determination to take him at that time at all events, and a move made by the deceased towards him with his pistol in sight, and a seeming intention to use it against the defendant for the purpose of overcoming all resistance. Under these circumstances, the error of the charge was material and prejudicial. At common law, if a party resisted arrest by an officer without warrant, and who had no right to arrest him, and if in the course of that resistance the officer was killed, the offense of the party resisting arrest would be reduced from what would have been murder if the officer had the right to arrest to manslaughter. What would be murder if the officer had the right to arrest might be reduced to manslaughter by the very fact that he had no such right. So an officer at common law was not authorized to make an arrest without a warrant for a mere misdemeanor not committed in his presence. If the officer had no right to arrest, the other party might resist the illegal attempt to arrest him, using no more force than was absolutely necessary to repel the assault constituting the attempt to arrest. We do not find any statute of the United States or the state of South Dakota giving any right to these men to arrest an individual without a warrant on a charge of misdemeanor not committed in their presence. Marshals and their deputies have in each state, by virtue of Section 788 of the revised statutes of the United States, the same powers in executing laws of the United States as sheriffs and their deputies in such state may have by law in executing the laws thereof. This certainly does not give any power to an officer at the Pine Ridge Agency to arrest a person without warrant, even though charged with the commission of a misdemeanor. These policemen were not marshals nor deputies of marshals, and the statutes have no application to them. By Section 1014 of the revised statutes, the officers of the United States named therein and certain state officers may, agreeably to the usual mode of process against offenders in such states, order the arrest of an offender for any crime or offense committed against the United States. This section has no such application. Referring to the laws of South Dakota, we find no authority for making such an arrest without warrant. The law upon the subject of arrests in that state is contained in the compiled laws of South Dakota 1887, section 7139, and the following sections, and it will be seen that the common law is therein substantially enacted. The sections referred to are set out in the margin. No rule or regulation for the government of Indians upon a reservation has been cited, nor have we found any, which prohibits the firing of a gun there, quote, for fun, unquote, nor do we find any law, rule, or regulation which authorizes an arrest without warrant of an Indian not charged even with the commission of a misdemeanor, nor does it anywhere appear that Gleason had authority to issue a warrant for an alleged violation of the rules or regulations. It is plain from this review of this subject that the charge of the court below that the policeman had the right to arrest this plaintiff in error without warrant, and that in order to accomplish such arrest, they had the right to show and use their pistols so far as was necessary for that purpose, and that the plaintiff in error had no right to resist such arrest was erroneous. That it was a material error, it seems to us, is equally plain. It placed the transaction in a false light before the jury, and denied to the plaintiff in error those rights which he clearly had. The occasion of the trouble originated in Gleason's orders to arrest him and in the announced intention on the part of the policeman, which they endeavored to accomplish, to arrest the plaintiff in error that night and take him to the agency, and all that followed that announcement ought to be viewed in light of such proclaimed intention. And yet the charge presented the plaintiff in error to the jury as one having no right to make any resistance to any arrest by these officers, although he had been guilty of no offense, and it gave the jury to understand that the officers, in making the attempt, had the right to use all necessary force to overcome any and all opposition that might be made to the arrest, even to the extent of killing the individual whom they desired to take into their custody. Instead of saying that plaintiff in error had the right to use such force as was absolutely necessary to resist an attempted illegal arrest, the jury were informed that the policeman had the right to use all necessary force to arrest him, and that he had no right to resist. He, of course, had no right to unnecessarily injure, much less to kill his assailant, but where the officer is killed in the course of the disorder which naturally accompanies an attempted arrest that is resisted, the law looks with very different eyes upon the transaction when the officer had the right to make the arrest from what it does if the officer had no such right. What might be murder in the first case might be nothing more than manslaughter in the other, or the facts might show that no offense had been committed. The plaintiff in error was undoubtedly prejudiced by this error in the charge, and the judgment of the court below must therefore be reversed, and the case remanded with instructions to grant a new trial. So that was the unanimous opinion of the court authored by Justice Peckham, and I want to break it down really quickly. First, the court answers the question of whether or not Bad Elk, under common law, had the right to use force in his effort to resist an unlawful arrest. The court held here that John Bad Elk was within his rights when he used lethal force to resist unlawful arrest. The court came to this conclusion after first deciding that the officers were in fact making an unlawful arrest. The arrest was determined to be unlawful because no judge had issued a warrant for Bad Elk's arrest, and Captain Gleason did not have the authority to order Bad Elk's arrest. Furthermore, the court found that there was no federal, state, or tribal law that forbade the firing of a gun for fun, as Bad Elk claimed he had fired the gun for. The court even went so far as to say that the only law Bad Elk could have possibly broken would have been considered a misdemeanor, and in order to be arrested for a misdemeanor, Bad Elk would have had to commit the crime in the presence of an officer, which he did not. So finding that Bad Elk's arrest was unlawful, the court held that under common law he was within his rights to use force in order to resist the arrest. The second question that the court was tasked with answering was whether or not the jury was entitled to know that Bad Elk was within his rights to use force to resist unlawful arrest. On this matter, the court held that the prosecution had erred when it had not instructed the jury that Bad Elk was allowed to use force to resist an unlawful arrest. The court also points out that instead of informing the jury of Bad Elk's right to resist unlawful arrest, the prosecution instead informed the jury that the arresting officers had the right to use any amount of force, even lethal force, in order to effectuate the arrest of John Bad Elk. The court describes this as a material error, which refers to false or misleading information or a disregard for certain evidence that could reasonably affect the jury's decision-making. So the court basically says that if the jury knew about Bad Elk's right to resist unlawful arrest, the verdict would have been different. So what became of John Bad Elk? Well, as per Peckham's opinion, John Bad Elk's case was supposed to be retried. Unfortunately, while awaiting retrial, Bad Elk died in jail of tuberculosis, which was known as the consumption at the time. A column from the Kearney Daily Hub, which was a newspaper based in Kearney, Nebraska, noted Bad Elk's death on August 3, 1900 with the following description. Quote, Sioux Falls, South Dakota, August 3rd. John Bad Elk, a Sioux Indian murderer who has been in jail here since April of last year, died yesterday of consumption. In March 1899, on the Pine Ridge Reservation, Bad Elk shot and killed John Killsback, one of a party of 3 Indian policemen trying to effect his arrest. He was tried, convicted of murder, and sentenced to be hanged in July of last year, but was granted a new trial." Unquote. Despite the case being over 100 years old at this point, it still has some relevance today, in that it is often cited online as evidence that a person can use force to resist an unlawful arrest. While this concept may have been upheld by the court in 1900, this concept has since become obsolete and is no longer advised. And it is no longer advised that a person resists or uses force to resist an arrest, no matter how unlawful that arrest may seem. The precedent set in Bad Elk v. United States started to become eroded in 1942 by academia, when Harvard law professor Sam Warner proposed repealing the Bad Elk precedent, instead arguing that a citizen had a duty to submit to arrest as long as the arresting individual could reasonably be considered a peace officer. This challenge to the turn-of-the-century case was widely accepted until the civil rights movement of the 1960s, in which it was once again argued that people should have the right to resist unlawful arrests. Also in the 1960s, subsequent court cases restricted the scenarios in which a person could resist an unlawful arrest, and the precedent was largely overturned by the Model Penal Code of 1962, which eliminated a person's right to resist arrest. And with that, we've discussed the background, the majority opinion, and the legacy of Bad Elk v. United States. Hopefully you enjoyed this episode, and if you did, please consider giving this video a like and or subscribing, and I will see you all in the next episode.